Hi, my name is Andrew, and today I will be teaching Real Property for the July 2025 MBE bar exam, and I'm here representing Ibis Prep. We are the leaders in educational excellence. So with Real Property, it's a very difficult subject on the MBE. I'm going to jump into deep water and start with mortgages. Mortgages are heavily tested and they need to be understood. So what is a mortgage? A mortgage is a loan secured by property. So there's the note, which is the IOU, the promissory note, the agreement to pay back money plus interest, and then there's a security agreement, which means in the event of a default or non-payment, they can rely on the property as collateral. So they could institute a foreclosure action. Let's take a step back and see who are the parties here. We have the mortgagor, who is the owner of the property, the one who is borrowing the money. And then we have the mortgagee, which is the lender, typically a bank, right? So there could be a senior mortgagee and a junior mortgagee, and it's typically determined by first in right, first in time. So the first mortgagee to acquire rights in the property will have priority in the event of a foreclosure action. There's something known as a PMM, a purchase money mortgage. A purchase money mortgage will have super priority, meaning no matter if it was second in time or third in time, whenever the PMM occurred, it will give that lender, that mortgagee, senior priority. And what the PMM means, the purchase money mortgage, is that the money that is borrowed is used to purchase the property itself. So look for a fact pattern where a homeowner borrows money and then uses that money to purchase the property. Well, that would create a PMM, a purchase money mortgage, which would give the lender super priority. So when we're talking about mortgages, a mortgagor can transfer their mortgage, and the next party can either take that mortgage subject to, or they can expressly assume the mortgage. If the new party expressly assumes the mortgage, that means that they will become primarily or personally liable on the mortgage. And the original party, the one that transferred the mortgage, will be secondarily liable, or they'll be known as a surety, right? Secondarily liable and surety more or less mean the same thing, and personally liable and primarily liable more or less mean the same thing. So if the new party expressly assumes the mortgage, they will become personally liable and the original party will be secondarily liable. If the new party takes the mortgage subject to, they will become secondarily liable and the original party will remain primarily liable. So you really need to look at the language and see, did they expressly assume the mortgage? Okay, now they're primarily liable. Or do they take subject to the mortgage and now they'll become secondarily liable? In the event of a novation, which is a substitution of the parties, the first party could be let off the hook and then the second party would take on the mortgage independently. In the event that the second party, the surety, pays the obligations of the mortgage, then they can seek reimbursement from the first party under the laws of suretyship. So that's kind of how secondarily liable and primarily liable work when we're considering a mortgage. When we're talking about a mortgage, there's some express terms that are allowed so long as they're reasonable and agreed upon by the parties. This could be like a no early prepayment or an acceleration clause or a due on sale clause. So a no early prepayment or prepayment fees, either of them, could be allowable, and that would prevent the mortgagor from paying back the mortgage early, which could be something that the mortgagee would want in case they wanted, lifetime payments or, payments that are dispersed over time. There could also be a due on sale clause, which means if the property is sold, the entire balance of the mortgage is due, or an acceleration clause, which means in the event that the mortgagor misses a few payments, the mortgagee can accelerate the entire balance of the mortgage. So when we think about a mortgage, understand that there's a principal of the mortgage, which is the amount borrowed, and then there's the interest, which is the amount on top of what's borrowed that the lender, seeks to gain for the arrangement. So in the event of non-payment, the mortgagee can seek a foreclosure action, which is the forced sale of the property. And the proceeds of that sale will go to pay back the senior mortgagee, and they will exterminate all of the junior mortgagees' interest on the property, so long as the junior mortgagees were notified and had an opportunity to attend the foreclosure sale. In the event that the mortgagor can buy back the property after the foreclosure but before the sale, so when the foreclosure is instituted but before the sale has occurred, Before the sale would be the equitable right of redemption. If the mortgagor can exercise that right after the sale, that will be known as the statutory right of redemption. And if you confuse them, just remember, E comes before S. So E is the right to redeem before the foreclosure sale, and S is the right to redeem after the foreclosure sale. Equitable right of redemption before the foreclosure sale, statutory right of redemption after the foreclosure sale. Again, mortgages can be really tough. There's something known as an equitable mortgage, which is just a mortgage that isn't really recorded or written, but it still operates as a mortgage, and the courts can enforce the obligations of a mortgage in that instance. In the event that the proceeds of the sale are not enough to pay back the senior mortgagee or the junior mortgagees, they'll have to seek a deficiency action against the mortgagor to collect from them personally. So again, mortgages can be really tough, but just make sure you understand the basics, what a purchase money mortgage is, that's gonna have senior priority, and then, statutory right of redemption would be after the foreclosure sale, equitable right of redemption would be before the foreclosure sale, and just some of the key fundamentals. Expressly assume means the new person is primarily liable, and subject to means the new person is secondarily liable. All right, staying in the deep water here, let's talk about the notice statutes, right? It could be a pure notice jurisdiction, it could be a race jurisdiction, or it could be a race notice jurisdiction. And you're gonna have to look at the language. On the actual question, they'll give you the statute that says, in this jurisdiction, any interest who records first will prevail, or any interest who takes without notice will prevail, or any interest who takes without notice and records first will prevail. If it's without notice, then it's a pure notice jurisdiction. If it's first to record, it's a pure race jurisdiction. If it's first to record without notice, that makes it a race notice jurisdiction. So what is a notice jurisdiction? Well, in a pure notice jurisdiction, bona fide purchasers will prevail. The last bona fide purchaser, the last person who took the property for value, without notice, and in good faith. For value means they weren't gifted the property, they actually paid for the property. And good faith means there was no bad faith. And then the key concept is without notice. Sorry. So notice can be actual notice, which means that they literally had notice. They knew that someone had a mortgage on the property. They knew someone had a lien on the property. They knew there was some interest on the property, right? There was an easement on the property. Then there's constructive notice in the forms of record notice and inquiry notice. Record notice means it was in the county records, it was recorded. Well, if it was recorded, they'll be ascribed with notice. And then inquiry notice means a reasonable expectation of the property would have put someone on notice. So, there's a question where someone's operating a farm on the property, and the person who buys the property is trying to say they didn't have notice that that person who was operating the farm had an interest in the property. Well, they would have to have inquiry notice. So any form of notice would defeat the prospect of being a bona fide purchaser, and that person would not prevail in a pure notice jurisdiction. But otherwise, if they took for value in good faith without notice, then the bona fide purchaser will prevail. And anyone after the bona fide purchaser can take upstream status in the bona fide purchaser's status under what's known as the shelter rule. So if Tommy takes as a bona fide purchaser and then gifts to Susie, well, then anyone upstream, anyone who came before Tommy is not going to have a claim against Susie because Susie took shelter in the bona fide purchaser status of Tommy. So BFPs will prevail in a pure notice jurisdiction. In a race jurisdiction, it's just going to be the first party who records. Just look to see who recorded their interest. Whoever did it first is going to prevail. And then if it's a race notice, it's the combination. They have to be a bona fide purchaser, and then they have to also be, the first to record. So there's two bona fide purchasers. It would be the first of them to record. So look for the language. Without notice would be a pure notice jurisdiction. First to record is a race jurisdiction. And first to record without notice is going to be a race notice jurisdiction. Kind of, tangentially related would be the concept of lien theory versus title theory. Lien theory is when a lender or someone who has a mortgage on the property has a lien on the property and not title, whereas in a title theory state, they have title. The key implication is that in a lien theory state, and that's what we presume on the MBE, a loan on the property will not sever a joint tenancy with the right of survivorship. Meaning if there's two parties, A and B, who have a JTRS on the property, and A takes out a loan on the property, that loan is personal to A. It doesn't really attach to the property itself, and it won't follow the property in the event that A were to die. So in a lien theory state, it will not sever a JTROS. And in a title theory state, it would sever the JTRS. And as I'm talking about tenancies, let's kind of transition into that. There are three different types of tenancies. There's tenancies in common, there's joint tenancies with right of survivorship, and then there's tenancies by the entirety. We presume a tenancy in common if they don't tell us. A tenancy in common means A and B are joint tenants, and if A were to die, then A's heirs would get A's stake in the property. A joint tenancy with right of survivorship means if A and B are co-tenants and A were to die, then B would survive A and B would get the entirety of the property. And then tenancy by the entirety means that there's a JTROS plus the element of marriage. You must understand that for JTROS, we need the unities of time, title, interest, and possession. So it has to occur at the same time. They have to have, 50% title each, or however much it may be, the same interest in it, and they have to have the same right of possession. When you're talking about joint tenants in general, they have an equal right to occupy the entire property, so they can't be ousted from use of the property. In the event that two joint tenants are fighting and they want to split the property, then you could order for a partition, and a partition could be a physical partition where they split the property in half, or it could be what's more common, a judicial partition where they actually have to sell the property and then split the proceeds. So again, real property, so many different directions we could go. Sorry. And I just want to start with some of the key fundamentals there with mortgages and with lien theory state and with the title theory state, with the different types of tenancies, and with the notice statutes. We can also talk about ways you can acquire title to property. So the easiest way is by having a deed, right? A deed is something that's written, it accurately describes the property. In most jurisdictions, it needs to be witnessed by two witnesses, not in all jurisdictions, but it needs to be written to comply with the statute of frauds, and it needs to accurately describe the property, and the grantees need to be identifiable. It can't say to all the people in Dade County. It would have to say to like Tommy, Johnny, and Susie, or it can't say to all my neighbors. It could say like to my next door neighbor to the left, right? But it has to be reasonably identifiable. And when a deed is delivered, it's delivered when it's transferred, and with the intent that it cannot be rescinded, right? So if Tommy delivers to Johnny and says, hey, if I ask for you to give this back to me, then that's not true delivery. But if he says, hey, Tommy, take this and record it when I die, that's delivery, right? One concept that they test is this concept of estoppel by deed, which means that if A transfers property that A doesn't have the authority to transfer, let's say A transfers it to his girlfriend, right? But it's A's mother's property. Well, when A conveys the property, it was invalid. But then later, A's mother dies and A inherits the property. Well, now A is dating someone different. So A wants to transfer the property to his new girlfriend, but A's already transferred the property to his old girlfriend. And unfortunately for A, under the theory of estoppel by deed, the earlier conveyance will be validated. So that's what that theory means, estoppel by deed. If someone conveys property that they don't have authority to convey, but then later are vested with that authority, the earlier conveyance, they'll be estopped from denying it. So that earlier conveyance will be the valid conveyance. Yeah, a lot of important things. About joint tenancy with right of survivorship, just a thought that I wanted to mention, that will supersede a will. So if A and B are joint tenants with right of survivors, and then B puts in his will that property goes to C, well, when B dies, A will survive because the JTROS will supersede the will. Now, if A and B are joint tenants with right of survivorship, and during the lifetime, B conveys B's interest to C, well, that will sever the JTROS and it will create a tenancy in common with A and C. So if it's conveyed during the lifetime, well, sure, that will sever the JTROS. But if it's devised in a will, then the survivorship aspect of the property will supersede the will, and the will provision will not prevail. So that's something important to note. Again, when we're talking about deed, talk about delivery, right? Deeds are, presumed to be delivered, to be accepted when delivered, right? And, it just has to leave their control. And then there's different types of deeds. There's a general warranty deed, a special warranty deed, and a quitclaim deed. A general warranty deed has the 6 covenants. And I have this fun little mnemonic for the football fans, SEC, quiet football game. S is for sizing, E is for the right against encumbrances, and C is for the right to convey. So sizing, encumbrances, and convey. Those are the present warranties that have to be brought at the time the deed is recorded or they're lost, right? Whereas the future warranties, quiet enjoyment, the right of further assurances, and the right of general warranties can be brought in the future. So quiet football game, quiet enjoyment, further assurances, and general warranties. So those are the warranties that come with a general warranty deed. Now, when there's a question about, suing under a warranty, recognize that those are about conditions of title. They're not whether there's termites on the property or some condition of the property. That would be a fraudulent misrepresentation or concealment claim. It wouldn't be a warranty claim. A property can be sold as a special warranty deed, which only, warrants for the time that the previous party had title to the property, nothing, upstream or outside the chain of title. And then a quitclaim deed, which actually makes no warranties. Understand the concept of merger, and this is tested actually in 2 ways on the bar exam. The first is that a contract merges with the deed. So if the deed's been recorded and the long convoluted fact pattern asks you, can Susie prevail on a breach of contract claim? The answer will be no, because the contract has merged into the deed. Another way that mergers tested, and I'll talk about this when I talk about easements, is common ownership of a property can merge 2 properties together and terminate an easement. So if A and B are neighbors and there's an easement and then A buys B's property, well, that will merge the properties and terminate the easement. So merger of a contract into a deed and merger when we're talking about easements, right? But getting back to the deed conversation, you're looking for deed formalities, you're looking for whether the deed was properly delivered, then the things that are mentioned on a general warranty deed, and the different other types of deeds and things of that nature, right? So, yeah, I did mention easements. There's, 6 different types of easements I can think of: express easements, implied easements, easement appurtenant and easement in gross, affirmative easement and negative easement, and easement by prescription and easement by necessity. Okay, so 8 different easements. Obviously, express or written, implied are oral or, they're assumed. Express easements, implied easements, and general easements usually run with the land, which is different than a license. A license is like a ticket to a hockey game. It's very temporary, where an easement will actually run with the land. An easement is like a right of use. An affirmative easement is a right to cross over or use property, and then a negative easement is a right to restrict, like, light or a view or something like that. So there's easement by prescription, which is similar to adverse possession. The elements are open, continuous, adverse, notorious, hostile for the statutory period. You see how it didn't have to be exclusive because multiple people could have the same easement by prescription. And then easement by necessity arises when a piece of property is hemmed in and it doesn't have access to a public road. The difference between easement and gross and easement and appurtenant is an easement and gross is personal. It doesn't run with the land. It's, a utility company or something like that. Where easement appurtenant is tied to the land, and it's usually, neighboring properties who would have a right of access over another. The remedy for misuse of an easement is typically a surcharge or injunctive relief. It's not going to be the termination of an easement. It's there are ways to terminate an easement, like abandonment or destruction or merger or release, right, an express release. Some of these types of ways could terminate an easement, but typically the easement will continue to run with the land and subsequent owners will be bound by those easements. In that moment, I talked about adverse possession. So adverse possession, you could have title by deed or you could get title by adverse possession, right? Adverse possession is like squatting on a property. Open, continuous, exclusive, adverse, notorious, and hostile for the statutory period. If a person takes with color of title, that means they take with a deed purporting title, but it's probably like a defective deed. Without color of title means they don't have any instrument purporting title. If you have color of title, right, then you'll adversely possess all that's described in that defective deed. If you adversely possess without color of title, it's just the property, that you enclosed or possess. For adverse possession, look for that continuous element, right? Like they've stopped doing it for a year or two, then it wouldn't be continuous. But there can be tacking, meaning another party can, if Tommy squats for 7 years and then Susie immediately starts squatting for 4 more, that would be 11 years to potentially reach a prescriptive period for adverse possession. And then if, let's say, 2 people, Tommy and Johnny, adversely possess together, then they'll take the property as tenants in common, right? Again, a lot of topics we can talk about with real property. Understand the difference between real covenants and equitable servitudes. These are promises tied to land. Equitable servitudes are typically remedied by injunction, whereas real covenants are typically remedied by monetary relief. There's different types of estates, right? There's fee simple absolutes. There's fee simple determinable. Fee simple absolute means you have like the absolute ownership of the property. Fee simple determinable means, fee simple to feasible, let's say. There's fee simple absolute, and then there's the feasible fees. And there's fee simple determinable, fee simple subject to conditions subsequent, and fee simple subject to executory interest. A fee simple determinable has durational language, so long as, while, until. Make sure you see that durational language. It can't be for the purpose that. So A to B, so long as it's used for religious purposes, is a determinable fee. A to B, for the purpose of creating a church, creates no binding effect in B. But A to B, so long as it's used as a church, means that once B stops using as a church, it'll automatically revert to A. The difference between a fee simple determinable with that durational language and a fee simple subject to condition subsequent is that the fee simple determinable has that automatic reversion, whereas the fee simple subject to condition subsequent will have that right of reentry that has to be exercised by the grantor. So fee simple subject to condition subsequent would be like A to B, but in the event of, the Dolphins winning the Super Bowl, then A retains the right to take back the property, right? And then fee simple subject to executory interest could be a shifting or springing executory interest. Springing executory interest, springing means it springs from the grantor to a grantee. So this property goes to B if B graduates from college. It's going from A to B. It'll spring from A to B if B graduates from college. With springing, there's only 2 parties. With shifting, there's 3 parties. A to B, but if B doesn't graduate from college by 2050, then to C. Well, it will shift from B to C. So shifting is from grantee to grantee. Springing is from grantor to grantee. Springing has 2 parties. Shifting has 3 parties, if you want to think about it in those terms. When I was talking about, conveying property and the merger of the deed and all that, there's a couple important concepts. One of them is the implied warranty of marketable title. The implied warranty of marketable title means regardless of express warranties, regardless of general warranties, regardless of all that, every sale for land has these implied warranties of marketable title, which means there's nothing wrong with the property from the eyes of the average buyer, meaning there's no mortgages, there's no liens, there's no threats of litigation, there's no encumbrances on the property, there's no strange zoning laws. It's not subject to some fee simple condition. It's not subject to something known as a right of first refusal, which means that the person who sold it to them has the right to buy it back. There's nothing on the property that is strange and would make it unmarketable, right? Like there's no easement over the property. There's no encumbrance on the property. If there was, that would make it unmarketable title. But recognize that the time to deliver marketable title is at closing. So if there's mortgage on the property, let's say $100,000 is owed on the property, but the sale is for $500,000, $500,000, well, the proceeds of the sale will be able to pay back the mortgage, and therefore there will be no problems with title at the time of closing. So the time for marketable title is at closing, and marketable title means there's no encumbrances or strange, interest in the property or problems with the property that would affect conditions to title. Now, you can, waive marketable title. You can agree to less than marketable title, but it is initially implied. So again, with that concept of there's the sale, right, the contract, and then the parties agree to it, and then there's the closing, right, and that could be 30 days later, let's say. Well, during that period in between, known as the period of escrow, where the money's held in a third-party account and, one party's doing due diligence and inspections on the property and such, during that time, under the theory of equitable conversion, which is recognized in the majority of jurisdictions, equitable ownership of the property passes to the buyer at the moment of the contract, not the moment of the closing. So during that period of escrow, the risk of loss will actually pass to the buyer under the theory of equitable conversion. Additionally, let's say either party were to die. A and B agree to, sell the property, the closing in 30 days. 15 days later, if either A or B were to die, their estate would still, have transferred equitable title to the property and will have to follow through with the sale of the property. It will be considered to have left their particular estates. So those are some implications of equitable conversion. I mentioned that thing where there could be a right of first refusal, which violates the rule against perpetuities. It's just a concrete answer. A right of first refusal violates the rule against perpetuities. The right of first refusal means that if A sells the property with B, but there's a clause that says if B ever sells the property, A has the right to buy it for market price, that's not valid. Why? Because maybe B could sell for more than market price, and that's going to violate the rule against perpetuities. For those of you asking, the rule against perpetuities means no interest in land is valid unless it must vest, if at all, within 21 years of the death of a life in being at the time the interest was created. So you look for the measuring life, right? Like, who's the last possible life, and see, is it possible that they could die and then more than 21 years will pass and we're not sure if it's going to vest or not. If something is going to either, A to B if B gets married, right? That's not going to violate the rule against perpetuities, because if B doesn't get married, it'll just stay with A, right? It has to be some period where we're not sure if it's going to vest at all. The sexy grandma, the fertile octogenarian. Grandma conveys property to all of my children who reach the age of 30. She has one kid who's 31. Well, that's problematic, because what if that kid dies the next year? Then grandma has a baby the very next year. Then grandma dies. Well, now you have this baby, and it's not sure if the baby's going to reach the age of 30 or not within the next 21 years. So we don't know if it's going to vest or it's not going to vest. So that's the concept of the rule against perpetuity. I generally tell students, shy away from picking the rule against perpetuity as an answer unless you know it really is the answer and you can kind of, add it all up. Again, like I told you, a right of first refusal would generally violate the rule against perpetuities. Those are some of the really fundamental key concepts. Just some little things like a realtor, there's a right to sell and a right to list. If a realtor has a right to sell, that means if the property sells, they're going to get paid their commissions. A right to list means they have the right to list it, but if it sells outside of their listing, they won't get their commissions. And they're only obligated, the seller, the person who hired the realtor is only obligated to sell the property if they do get a bid at the full asking price, right? An attornment is a substitution of landlord. So if A is the landlord and B is the tenant, and then C wants to come in and be the new landlord, that's known as an attornment. When it comes to landlords and tenants, there's certain duties. The landlord has the duty of habitability and quiet enjoyment, and the tenant has to pay rent and not commit waste. There's different types of waste. There's actual waste, like you destroy the property. There's ameliorative waste, meaning they improve the property but still constitutes waste. And then there's permissive waste, meaning like they let the property rot. This waste doctrine will apply to life estate tenants as well, not just regular tenants, and they have these duties. In the instance of a life estate where there's a life estate tenant and then a remainder man, there's certain duties. The life estate tenant has to pay the living expenses, the taxes, the interest, right? And then the remainder man will pay the principal of the mortgage, because the remainder man is the one who's actually going to inherit the property and would be able to potentially sell it. The only time the life estate tenant does not have to pay the interest and taxes on the property is if the land is vacant, unproductive, and they're getting no rental or, possession value out of it. But otherwise, the life estate tenant does have to pay the living expenses associated with it, the taxes and the interest on the property, whereas the remainder man will pay the principal of the mortgage. Remember when I talked about waste doctrines? That's important. It could be for the life estate tenant or for the actual tenant, for a landlord-tenant. That concept of quiet enjoyment comes up twice, right? The landlord has that duty, and it's also one of the warranties of a general warranty deed. And then habitability can come up twice as well, because habitability is a duty that's delivered by the landlord, and then habitability can also be a duty of a builder, right? It's not usually a duty of marketable title, it's not a duty of a general warranty deed, but a builder of new construction home does have that duty of habitability in all jurisdictions. In some jurisdictions, it'll even transfer to the subsequent seller. But the first builder to the buyer, they will have to deliver that duty of habitability. There's something known as retaliatory eviction. So if a landlord and a tenant have a dispute and the tenant prevails, and then like 3 weeks later, the landlord wants to evict the tenant, and it's based on the litigation, that would be known as a retaliatory eviction, and that really wouldn't be allowed. Some of the disputes you'll see between the landlords and tenants, just kind of think back to when you were in college or whatever, and you stayed in a property and how things may have gone, and you'll tend to be able to prevail. I mean, I'm thinking about all these different real property issues that I could talk about, but I really don't want to overwhelm people. Remember, real property, it's under my legs. Contracts for sale of property have to be in writing, so it really can't be oral unless there's, promissory estoppel or partial performance. And for partial performance, there needs to be two of the three: possession, payment, or improvement of the land. So a lot of really difficult things you could look for on real property. I think it's the toughest subject. I feel like I touched on a lot of different things. I'm going to be coming back and making more detailed videos for all these subjects, but I really hope you found some value out of my real property MBE video today. Thank you all so much, and I hope you have a great day and good luck on your exam.